Good morning. It is 8:30 a.m. on Friday the 11th of June 2021. My name is Arran Hunt. I'm a partner here at the law firm Stace Hammond and I head up the immigration team here. As always, this is not legal advice. This is just our commentary on immigration here in New Zealand. If you want legal advice, please send us an email. That is in the description down below. You'll find the address. It has been a quiet few weeks, at least in regards to immigration law changes. Very busy few weeks for us for client matters and work. There's been very little news to report on. Now, we've been working on another piece I was going to actually be recording yesterday, but then the Minister came through and made some changes to the law. So we're sort of just rejigged that. That will come through perhaps next week, looking at the number of the obvious issues that are happening right now in immigration. And instead we're going to focus on a few other things today. The first thing, of course, is the changes that were announced recently to the visas here in New Zealand. We'll then be looking through a topic that actually we've been asked to cover a number of times, and that's character waivers and character issues. We're going to go through what they are, how they're applied, and sort of the issues around that process. Now tonight I'm also going to be doing a live Q&A on the Hindi Punjabi Facebook channel we've done videos for before. We'll link to that in the description below from 6 p.m. New Zealand time tonight, the 11th of June, probably for 1 or 2 hours. Tomorrow we're actually going as a firm, Stace Hammond. We have a trust called the Kai Tia Katanga Trust, which is actually going out tomorrow to plant trees to help against erosion. So you need a bit of sleep tonight, so probably do an hour or two on that live Q&A online tonight. Come check it out if you want to talk to me live or see any questions that get asked to me. Now, first thing I'm going to cover is the visa extensions and the changes that were announced by the Minister this week. So we're going to get straight into those. First thing is there's around 10,000 people who are believed to be in New Zealand on a working holiday visa or on the supplementary seasonal employment visa that a lot of them changed across to. Now, if those visas are due to expire between 21st of June 2021 and 31st of December 2021, they'll be granted an extra 6 months onto that visa just to help manage ongoing labour shortages. Now, those are going to allow them to work in any role. It's just going to mean that they can be here for a bit longer. Now, the next thing was essential skills visas for jobs paid below the median wage are currently on a 6-month visa. Now, that 6-month visa came into place early last year. It used to be 1 year. They made it 6 months on the basis there will be lots of migrants coming back to New Zealand who need to work, lots of locals coming back to New Zealand who need the jobs. Of course, that hasn't taken place, so they're now extending that back out from 6 months to 1 year visas. So it's supposed to happen in January next year. They're going to bring that forward and take it place now. So that means that any those lower skilled applications which are made now and that are granted in the future will be for 1 year rather than 6 months. It doesn't mean that those who already have that 6-month visa will get an extension. Unfortunately, you won't. It will just be those who apply now and will get 1 year rather than 6 months, which I think is great because 6 months visas were, I think, a silly idea in the first place. The stand-down period, so for those of you who are on those lower skilled visas, and there was the idea that you've done 3 years on those low skilled visas, you have to leave the country for a year. Now that stand-down period has been delayed again and again. It's now delayed until July 2022 when it will come into effect, unless they delay it again. Again, this is to show that we need migrants here in this country. Now, the big point was, as I've been asked so many times, the median hourly wage rate will increase to $27 per hour from 19th of June, as we expected. The Minister has said, and this was the strange part, that the wage rate was set following public consultation, which it's arguable. We'll say that. We'll be kind. We'll say it's arguable. The wage rate is set based on the June quarter results from Statistics New Zealand. They do a national survey, look at what the wages are across the country, and they set it at what is the median, what is the very middle rate being paid. That's $27 per hour as of the June quarter last year. Now, that is the requirement of how this rate is set. It is not set based on public consultation. There was public consultation. Perhaps it was whether they put it into place or not, because the median wage actually dropped after the June quarter last year to $26.50. So perhaps that was what they meant by public consultation. But the figure itself, 27, that is set by Statistics New Zealand based on a factual situation. Now, those who are applying for a visa from 19th of July will need to meet that $27 per hour requirement. Those who are applying prior to that should be required to meet the $25.50. If your application is in queue while that change takes place, they should apply the earlier rule, not the later rule. So it comes down to the date that you apply as to what the requirements are. Those who are already on visas, it doesn't change your requirements. It'll only be an impact when you go to get your new visa past 19 July. The increase will also apply for skilled migrant category applications. However, it isn't clear if it will apply to those already in the pool. Now, if draws restart before 19 July, which we don't believe they will, but if they do, then great, the $25.50 requirement will apply to those who are drawn out. Arguably, it comes to this in a second, which then we would expect. So if they don't restart by that point, we would expect the government will probably go through and make it requirement for those submissions already in the pool. So those 9 or 10,000 applications that are already in there will then need to meet that new requirement. This would be in line with the government's sort of immigration reset they've been pushing, as it would force thousands of people from that pool, which would then of course mean they wouldn't go into this very long residency application line, which the government is doing very little about. We're hopefully proved wrong there, but the government has the right to make those changes, because these rules apply for when the application gets made, not when the expression of interest is made. So, as to when the draws will restart, which they get asked again a lot when they're going to start the skilled migrant draws, the Minister was due to announce that in March, and nothing was announced in March or April or in May. Now, showing this sort of approach, keeping people in the dark, shows that we don't believe he will be looking to do any favours to those waiting in the pool, or ultimately to the businesses that employ them, which is why we think they probably will apply the new higher wage rate as a requirement to those who are already in the pool. But we'll see what they do there. The Minister, again, in the press release, which we'll link to below, talks about the same long-term view about training New Zealanders that every other government I've ever seen make, and which the employers are being expected to deal with. The government is providing this end target where we want to have all of this employment done by locals, by citizens, by residents, but then is forcing the employers to undertake the cost and hassle to reach that target, not actually sort of make changes themselves behind the scenes, just basically shut off the borders and let you all deal with it. Now, this did come out of the blue. This change, these recent changes in the last few days, came out of the blue. They weren't expected. It appears that rumours started coming around on Wednesday morning that there was something coming, and it appears to have been provided pretty quickly once details of a restaurant association press release started going around at the same time. Suddenly we hear this government announcement of changes that weren't expected. Now, we'll link to the press releases in the description below so you can see them. Strangely, the government press release went to the media first before the public, which was unusual. Usually it goes to the BIHA website, public release it to government, they send it out there. So that was an unusual thing we don't usually see from the Minister. Now, the figures for the Restaurant Association, which sort of prompted this change, we believe, or people in the industry are believing, are kind of interesting. It sort of shows the number of members of the association who have difficulty filling roles. Now, 92% of members of the association report they can't fill roles in the senior or high skilled levels. 93% can't do it for mid-level roles, and 73% can't do junior or low-skilled roles. Now, for Auckland, it's 96% for high, 100% for mid-level, and 87% for junior roles. In Queenstown, it's 100, 78, and then 100. So what it means is that across the board, there's at least sort of 3/4 of companies, if not more, trying to fill these roles and having a difficulty in doing so. So the changes just announced by the government actually help a little bit with the low-skilled roles by providing that 1-year visa over a 6-month visa and extending those working holiday visas out for 6 months more. It doesn't really help with the mid or high skill level roles. These are roles that cannot be quickly and easily trained. Mid-level, you probably train some of the low-skilled guys up to mid-level, but it takes a number of years of experience or qualifications to do that high-level skilled work. Another report actually released yesterday shows that job adverts had increased 5% month on month Now we're comparing the number of adverts now compared to the same sort of seasonally adjusted period before COVID. We're 20% up on the highest point we previously saw. So the job market is absolutely booming. There's a lot of jobs out there and nobody to fill those jobs. So this is not being helped by this policy to restrict immigration by the government and to do so with its immigration reset. So at the same time that other countries are seeking immigration and seeing that as a way to recover from COVID-19, we're sort of battening down the hatches and blocking things out. It's great to train more locals, we're not against that, but it takes time, and that's why New Zealand needs migration. Now we'll look at character waivers. Now this has recently become an issue for a number of nurses who are going to be coming to New Zealand to do their CAP course, which allows them to bridge their experience and qualifications across to be used in New Zealand. A number have asked us to comment on character issues and character waivers, so we're going to sort of do it in this video. I actually videoed this section several times last night. It's been a few hours going through and recording it again and again, but it's easy to get lost in the detail, so I'm going to record it again this morning, a bit more refreshed, and try and simplify it a little and give it a bit more structure in how I sort of go through it. There's a lot of information here, so I will try to structure it in a way that's easier to follow, but there may be parts which go perhaps a bit further. Okay, so we'll come from the basis that character requirements all come under A5 of the operational manual. Now if you hear me refer to a letter and then a number, that's a reference to the operational manual. It's the instructions that Immigration New Zealand are required to follow. These are available online for anyone to look at. They're public information and is the best place to get any answer to any immigration requirement. You'll often see me responding to messages on the YouTube comments or on Facebook or on the groups with go have a look at H5.10 or A545.1, which we're about to talk about now, as that will often be the best place to look for these things, much better than looking at just a general website or even an immigration website themselves. Look at the operational manual, that's sort of where the actual rules are. Now under A5.1 there is a base requirement for all applicants for visas to be of a good character. A550 covers those who have a risk of hurting New Zealand's reputation, and which is a rare group which I probably won't cover any of you to form that area because it's a very rare sort of high level threshold group, so we'll ignore A550. A545 is the more general group. You're probably aware of the need for police certificates for most applications, but this goes further. So we'll go through the base requirements that can trigger a character issue under A545. To start with the police side, anyone who has been convicted of at any time in any country any offence against immigration, citizenship or passport laws has a character issue. Anyone who at the time of the application has been charged, is under investigation or is being questioned about an offence in any country that carries a sentence of 5 years or more in prison has a character issue. Anyone who has been at any time convicted of an offence anywhere for which they were imprisoned has a character issue. So you've been in jail anywhere, you've got a character issue. Anyone who has been convicted of an offence in New Zealand that the court had an option to impose a prison sentence of 3 years or more, whether the court actually did that or not, has a character issue. So if you've got a conviction in New Zealand of an offence where there was a possibility of a prison sentence of 3 months or more, then there's a character issue there. Now, driving while intoxicated falls under this, because under the Land Transfer Act that has a maximum imprisonment of 3 months, and that 3 months triggers that 3 months or more threshold, so that's a character issue. This then brings us to the most controversial part of A545 and the main topic of this video. This is A545B includes those who, in the course of applying for a New Zealand visa, have made any statement or provided any information, evidence or submission that was false, misleading or forged or withheld material information. Now falling under this category does not mean you won't get a visa, and a character waiver process is in place that it should be followed by immigration. A545.1 is where that sort of process is sort of detailed to some degree. It requires the immigration officer to consider a number of items. They cannot automatically decline the application, which is great. They have to actually follow this process. They need to consider how significant the false or misleading information is, whether you can provide a reasonable or credible explanation, and whether you can show there was no intention to deceive Immigration New Zealand, and they must give you the chance to actually do that and provide that. So they need to really also need to look at the reason for travelling to New Zealand, surrounding circumstances, and if there's compelling enough reasons to make an exception, including things like public interest. So immigration then needs to look at the reason for the travel, the impact of the misinformation, whether there was a good reason to provide the misinformation or there's no intention to mislead, and other factors like public interest. So there is sort of things they have to do as a process, and as part of that, they have to give you the chance to respond and provide that information as to why you provided misleading information. Now, for those who are in New Zealand and applying for visas from within New Zealand, we've found that character waivers for convictions have been very fairly judged. We've had a number of clients who have had a number of character issues, some minor, some fairly significant. For the more significant ones, we have shown that those in our applications to immigration, that those factors are no longer an issue, perhaps by showing the person has moved on, they've changed their life, they've improved. Typically and strangely, prior convictions are actually easy for Immigration New Zealand to provide a waiver for, in our experience. Where a court has found someone guilty of an offence, Immigration New Zealand are willing to see that it was either a minor mistake or perhaps the person has changed or grown from that, even just a year or two later. Providing Immigration New Zealand with incorrect information seems to be handled very differently to a conviction. So here's the process that immigration would generally follow. Immigration believes that someone has provided misleading information. They are required to provide the applicant with an opportunity to supply a reasonable and credible explanation or other evidence that they did not intend to deceive Immigration New Zealand. So they need to give you a chance to respond, to apply for the waiver. The immigration officer then sends the information off to another officer to review and see whether a character waiver should be granted. Now they'll do a list of pros and cons, so reasons to say yes, reasons to say no. The idea is that after reviewing that list and doing that list, they will decide if a waiver is granted. At that point it goes back to the original officer. If a waiver is declined, then the visa won't be granted. That's just how it is. If a waiver is provided, then the immigration officer will ignore that character issue and process the visa depending on other factors. If you get granted a waiver and then get a visa, then that is great. However, if you ever need to apply for another visa, even if it's years later, you could still go through this process again if an alert remains on your file. And when the new application is made, another officer will look at it again, do another character waiver decision, and may decline you a character waiver even though the earlier one was granted, despite nothing having changed except that more time has passed since the issue took place. This is an ongoing issue where we see this as being a breach of natural justice, that you've been had a decision looked at by immigration, they have said that yep, you're okay, we'll let it go, but they'll keep trying you for it again and again until they find you guilty, which is not really how the legal system here in New Zealand works. At this point, we should also mention that the Immigration Act does actually allow for an offence for people who mislead Immigration New Zealand, and this is something we do see sometimes in these character waiver decisions. It's found under Section 342 of the Immigration Act 2009. The difference here is that the wording from the operational manual and the wording from the Immigration Act differ on the word knowing, and it requires the person to have provided that information knowing it was misleading or incorrect or false when they did so. Now, with any type of offence, it has to go through a court. So there needs to be a charge laid against the person for committing that offence. They have to then go to court. They have a chance to defend themselves, to face their accuser, as it said, and then the court looks at it and makes that decision. We have very rarely ever actually seen these take place. Very, very rare, never against our clients. However, what we do see is we see these character waiver decisions making reference to this section. One review we looked at recently noted how serious a Section 342 offence is, which is true, it's a very serious offence. However, our client wasn't found guilty of that, they wouldn't have been charged with that, but the immigration officer doing the character review said, wow, this is an offence under the Act. It's like, well, only if a court says so, and in these cases they haven't. So only the court can say that someone is guilty of a Section 342. It's something that we often do see Immigration New Zealand officers do. Well, we sometimes see it, is they will try to say, well, you've misled us, and that's an offence under the Act, when it's only an offence if a court says so. So be very cautious there. So this is just jumping ahead. So this is so there is a set of things the immigration officer handling the waiver review needs to consider. The issue here is that, especially for those offshore, we've seen that list not really being followed. The reviews will often show a long list of positive reasons and one negative reason. That one negative reason being that information was provided which Immigration New Zealand felt was misleading or incorrect. So even though you have that one small issue that is not a criminal offence, it's not an offence, as I said, this is just often a mistake or an error, applications will be declined despite there being this long list of positive reasons. Even years later, they will still be declined. We have seen that with a few of our clients coming to us saying, hey, please help us out, Stacey Hammond. Where there were actual convictions of breaking the law, they're often being forgiven by Immigration New Zealand. Misleading immigration isn't. That seems to be something which the officers just will not allow and will go forward for much longer than any sort of court provided conviction. Now let's have a look at, in the context to our nurses and doing their CAP course, to try to set the groundwork there of how these things work. Now these are trained, qualified and experienced nurses. The Nursing Council in New Zealand has reviewed their applications and given the invitation. They've reviewed the qualifications and the experience and said, yes, this is all good, come to New Zealand to train. They've then paid $10,000 fees, the applicants have, to train here in New Zealand to do their CAP course, and under the critical health border exception, they're entitled to enter New Zealand to study once a border exception visa is granted. It is in there, has been in there since the very beginning when they started providing exemptions soon into the lockdown last year. However, we've had dozens of applicants come to us after being declined this visa on the basis that they have misled Immigration New Zealand. Now we're sort of trying to break it down into three bare categories. There's a little bit of overlap between them. People can sometimes fall in more than one of these categories, but it sort of largely covers most of those we've spoken with. There is those who, without realising, have used an unlicensed agent to assist them. You know, as the agent has done the application for them, they often weren't aware they weren't allowed to use an unlicensed agent or advisor to assist them with their immigration. Now, Immigration New Zealand has then called them and said, hey, you've done this, and they've panicked and said, no, I haven't. And which is often, you know, it's a common result when you get called up or out of the blue by an immigration agent, immigration advisor, immigration officer, sorry, to just. There are those who, without realising, have used an unlicensed advisor to assist them. You know, as the advisor has done the application for them, they weren't aware that they couldn't use an advisor to assist them. And at some point they may have worked it out or found out. So then Immigration New Zealand's given them a call and said, hey, I've used an unlicensed advisor, and they've panicked and they've thought, oh my goodness, I've done something wrong, and they've just said no. You know, they often come from countries where they don't really trust the government like we trust ours. Immigration has then said you've misled us and declined the visa without sort of no allowance there for perhaps them not being aware of the process. There are those who may have had a friend help and may have asked to use a friend's credit card as they may not have had their own credit card to make payment for the application. When called by Immigration, they've said, yep, I had a friend help. Immigration said, no, we don't believe you. We think you've had an unlicensed advisor help and you've misled us and the visa is declined. The third group is those who may have used an agent but for another purpose, such as booking their education or their CAP course. We have one application where Immigration actually refers to the agent's name appearing on a letter from the education provider of an offer of a place in the course. Immigration has mentioned this name, seen the word agent on a document, even though it's not an immigration agent, and has assumed it's an immigration agent, and declined the visa, when there really was no basis there to say that this person was helping with the immigration. They weren't. They were listed, and actually if you Google their name, they're an education agent. They help people book education courses. Now we believe that all of these in reality are either minor issues, like very minor issues, or not issues at all. However, they've been used as a basis for keeping nurses out of the country. And the character issue leads to a second issue, which is bona fides, or someone's intention, which we're going to cover now. So looking at the decision by one officer and one of the decisions we've seen, the officers said, "We are not satisfied that the principal applicant is a credible applicant for a visa and as such does not have a genuine intent in New Zealand as a critical health worker." So that's there, okay? Does not have a genuine intent in New Zealand as a critical health worker. So because they believe that the applicant attempted to mislead immigration on one minor point, because if they had help filling out a form, they believe that they are not being honest about their intention in New Zealand. Because they have mistakenly used an unlicensed advisor, this trained nurse with years of training, years of experience, who has spent $10,000 in education in New Zealand so they can be a nurse here, immigration appears that they believe it's all a lie, it's a ruse, the person's not being honest in any way whatsoever. This is called a bona fide issue, that someone is not genuine with their intent to travel to New Zealand. We can understand the thinking behind the determination being made. We don't believe there's any indication the person intends to be anything other than a CAP student and then a nurse. The fact that they may have made a mistake with their application does not mean they're not genuine. The issue, however, goes further with the current borders being closed. As we said, there is a requirement for Immigration New Zealand to provide applicants with an opportunity to respond when the character waiver is taking place. The trick here is the word applicant. With the border being closed, any applications needs to go through a border exception. This starts with an expression of interest, which in itself is not an application, it's an expression of interest to do an application. H510C allows an invitation to apply for an application to be provided based on a number of factors, but one of those is that the information available does not indicate any character or bona fide issues. So if there is a character issue or a bona fide issue, it means that no invitation to apply for an application will be granted. So as it is not an application but an expression of interest, immigration do not need to apply the character waiver test and do not need to provide people with an opportunity to respond to these accusations of there being a character issue. So those rules in A545.1 do not apply. The character issue still needs to be resolved, and there is no easy way to do that. Immigration's decision on the character issue is difficult to challenge, as they won't allow applicants to get to a point where they can be challenged, which is the application point, because no application is allowed to be made because they can't get an invitation to do that because the EOI is stopped at the very first point. We believe that this is showing a really uneven handling by Immigration New Zealand. The approach of handling any misleading information, whether intentional or not, as being more serious than a criminal offence is in itself a breach of the operational manual. This approach is used repeatedly to prevent people with a past wrong from ever coming to New Zealand. They have to go through these hoops again and again, even if they're found that they have not been, even if they find that there has not been an issue with one visa, the next time they apply for a visa, they have to go through it again. Now, this is a breach of natural justice. That the fact that they may be found not guilty once by immigration, who of course aren't a court, but then get tried again and again and again. The process does not allow for a fair review of character issues. And immigration's approach of mislead us and everything you say is a lie doesn't fit in with the operational manual. For the nurses caught by this and the other clients offshore we're working with to resolve these character issues, there needs to be a better way. If immigration is going to treat its own decisions as an indication that offence has incurred, then it needs to provide the right to have a third party to review that decision. It needs to provide a right for the applicants or the expression of interest, people who provide the expression of interest applicant, to actually respond to these accusations. The current procedures just do not allow that. With the border closed, these people are generally left with very, very few options. Now, we've said it a number of times that the vast majority of immigration staff are fantastic to work with and they do an amazing job, and we work with them on a daily basis and you get to know them quite well, a number of them by phone and by name, and you have a history with them. But there is a few rare people, and a few of the internal procedures they have in place, especially those that have been rushed through because of the border being closed so quickly, just seem to be wanting to punish applicants for making a past mistake, completely ignoring all the other factors that they are required to consider. We'll keep working with several nurses to try and resolve these issues. Even this week we saw 10,000 nurses leave work to protest, demanding more support in their industry, demanding more nurses to be hired. these nurses from overseas, these are trained and experienced. They want to work here. They want to provide that support. They've put their money into coming here to do that training. And those of you who have been in hospital will find, like when I've been in hospital for my appendix burst and a few other surgeries, these migrant nurses were fantastic. We believe that they should be given a fair chance to actually be here and not just being blocked because of perhaps a silly mistake or a misunderstanding from immigration. And that is it for today. We have another video coming out at some point when the workload allows it. We are fairly busy, and I've been doing 7 days a week these recent weeks. Until then, next time, kia kaha, stay safe.